you.
All right, we will hear argument now in our last case of the day, number 24-2081, Winnebago Tribe of Nebraska versus United States of the Army. And Ms. Wright, when you're ready.
May it please the Court, my name is Beth Wright, and I represent appellant the Winnebago Tribe of Nebraska. Here with me in the courtroom today are current and former Winnebago tribal leaders. The district court should be reversed. NAGPRA's purpose is to provide Indian tribes with a statutory right to bring home the remains of their own citizens from places they do not belong. NAGPRA provides Indian tribes additional rights to ensure repatriation is tailored to the unique needs of Indian tribes.
Counsel, I'm sorry to interrupt, but before you get to the merits of your argument, can you just explain to me sort of why we are here? I'm looking at this letter from the Army from December 23, offering to return the remains of Samuel and Edward at the Army's expense in a dignified and respectful manner. There are a bunch of details. So why is there still a justiciable case or controversy in front of us? It seems like the only question is sort of which authority will be used to effectuate this return.
Yes, Your Honor. A few points to that. NAGPRA itself gives any person a cause of action for any violation of this chapter. So Winnebago has a right as a sovereign nation under NAGPRA to bring home the remains of its citizens, and the Army has not said it will return the remains to the tribe itself. It will only return the remains upon the identification of a closest living relative.
Oh, I thought we were already past that. I thought I read in the briefs that they'd kind of they had taken a very liberal reading of this regulation and were prepared to do it in this case. I mean, if you think this. But you're saying all of this is actually contingent on a condition that can't be satisfied in this case?
Yes, Your Honor. Under the Army's process requires two affidavits.
No, I know what the Army's process looks like on writing, but I thought this letter was saying this will happen. But you were saying, no, this is just a letter saying, if you satisfy this other condition, we will do this.
Yes, Your Honor. And as Winnebago pled in its complaint, it attempted to identify the closest living relative, but because of the circumstances surrounding Samuel and Edward's death, it was unable to determine who that person was. Samuel and Edward died as children without any lineal descendants of their own, and now asking the tribe to identify who that person is a challenging task. And NAGPRA not only provides tribes a right to request repatriation and facilitate repatriation as a sovereign nation, it provides tribes additional rights that don't appear anywhere in the Army's process. Some of those rights include mandatory repatriation under the Army's process. Return of remains is just discretionary. Some of the additional rights...
Right. But those, it seems to me, once the Army says, but we are using our exercise to return the remains to you, it really wouldn't present a justiciable controversy. But you're saying the Army is not saying that. They have not told you they will return these remains.
Yes, Your Honor. Just briefly, the district court erred in dismissing Winnebago's action because it distorted NAGPRA's plain text and because it violated the standard of review by failing to accept the truth of Winnebago's facts. I have three main points. First is that the district court's ruling creates a holding or collection barrier to repatriation that has no basis in NAGPRA's plain text. Second, Samuel and Edward's remains are part of a holding and collection. And third, the district court misapplied Thorpe v. Borough of Thorpe.
Well, let me ask you, in terms of the breadth of the statute, if this statute is interpreted without the holdings and collections requirement, won't that make Native American remains within federal control subject to disinterment?
Not necessarily, Your Honor. If there is no holdings or collections requirement, which is our first theory that under 3005A4, a tribe doesn't have to show that there is a holdings or collections in order to be entitled to repatriation, a tribe still has to prove cultural affiliation with a specific set of remains and identify a specific set of remains that's in the government's possession or control in order to be entitled to repatriation of those.
And so secondly, does the line such Native American human remains in the statute refer to those that were eligible to be in inventories or summaries?
No, Your Honor. The specific language in 3005A4, which I think you're talking about, is not included upon any such inventories. The text ends there. There's no other language in the statute that says they're not included upon inventories, but they're still subject to the inventory provision.
So let me give you this scenario. Obviously, this cemetery is adjacent to the War College, and it has signs about people being able to tour and view the graves and that sort of thing. And maybe another qualifying fact that I can't recall right now. Would that scenario not at least make the remains qualify under the holdings definition, if not the collections definition for disinterment?
No, Your Honor. Not the mere availability of a tour makes remains a holding and collection.
Does make it.
Not the sole availability that you can tour a site and see the graves. That's not the only fact that makes remains a holding or collection. What makes these remains a holding or collection is that they were buried at Carlisle without consent of the tribe or the families, and then the government dug them up in 1927 and moved them to their current location, again without consent of the tribe or the families. And after that, the government has since treated these remains consistent with the ordinary definition of holding or collection. Some of those facts include that the government does use the remains as part of the walking tour, but other facts include that the government has studied these remains through ground-penetrating radar surveys and research reports, that the government has called Carlisle Cemetery specifically a repository for the remains of...
So these human remains are in the grave, right? They are in a grave.
They're in the ground, yes, Your Honor.
What's your best argument from the statute that it creates any obligation regarding human remains that are still currently buried?
Well, Your Honor, the purpose of NAGPRA is to...
Well, like in the statute, though. So the statute seems to address two kind of groups of human remains and artifacts. One is human remains that are buried, and the statute, like in 3002, addresses, if they are accidentally discovered on federal land, what is your obligation? If they are excavated with permission, what is the obligation? Right? It's all of the references to human remains that are buried is about unearthing them. If they are discovered, if they are excavated, here's who own. You don't own, but here's who controls, etc. And then the statute, in other provisions, the Act talks about human remains that have already been excavated, that are in holdings, in collections, or maybe are otherwise held by these entities, not in holdings or collections. Neither of those groups seems to be talking about who controls or any obligation regarding human remains still in the grave. Is that a correct reading of the statute?
No, Your Honor. Under 3005, it mandates that when a federal agency or museum has illicit possession or control of Native American human remains, and upon a valid repatriation request, that the federal agency return those remains to the tribe or the requesting entity. There aren't...
But where's the... I guess I'm just troubled by the fact that when the statute is... When it's talking about buried remains and obligations regarding them, all of the language is, removal, excavation, these sorts of words, and none of that is in 3005. There would have to be an obligation to first dig up, to first disinter, and that not only is, I don't see that in the statute.
Well, under 3002, it doesn't say that you can never dig up Native American human remains. It does say that you can dig up human remains if you follow these certain procedural
Right,
steps.
but where's
And
the
so-
obligation to do it?
Well, there is an obligation to seek a permit under ARPA, under the Archaeological Resource Protection Act.
Right. If anything, the statute seems to really want to limit that and say we are leaving the remains where they are unless, right, Section C says unless it's only permitted if you can satisfy certain requirements. That seems to be communicating a purpose that this statute has nothing to do with human remains buried in a cemetery on federal land.
Well, under the Archaeological Resource Protection Act a permit is not required if you are complying otherwise with federal law. So we didn't really brief the permit scenario necessarily, but it doesn't mean that you can never excavate Native American human remains only if you do these things under the options provided for obtaining a permit.
Right, but our question here is, does this statute create an obligation to disinter buried human remains, and where is that obligation in the statute?
There is no specific language that says the federal agency must disinter or must do something to return remains, but the fact that 3005 is a mandate on federal agencies to return Native American human remains contemplates that there would be scenarios where they would have to take on different measures to actually return the Native American human remains that they don't have consent to continue possessing.
Well, Ms. Wright, let me ask you this. Tell me how we can interpret the statute to put the remains back in the control of the tribe.
Just through 3005A4, Your Honor. Under 3005A4, remains not included upon any such inventory are these very scenarios of Samuel and Edward. Samuel and Edward were not listed on an inventory, so this broad language in the statute is contemplating scenarios where remains would not be listed on an inventory, remains would be intentionally left off an inventory, remains wouldn't be subject to the inventory provision.
But the inventory provision only applies to holdings and collections, right?
Yes, Your Honor.
So if there's a cemetery on federal land, it's not covered by the inventory provision. Right? That's right.
Well, because holding or collection isn't defined by the statute, you look to whether, based on the facts, is the government or entity treating these remains as a holding or collection. And so a holding or collection could potentially be a cemetery as it is here, because based on the facts, the government has treated this as a holding or collection by the fact that they moved these remains from their current burial spot to this location in order to build a parking lot, and because they have demonstrated their intent to treat Carlisle Cemetery not as an ordinary cemetery, but as a place that they've called in their own words a tribute to Native Americans, a historic site, and there's the facts in the complaint that discuss how the government would not return remains to tribes when they asked, because they wanted to maintain the character of the cemetery.
Does that apply to like Arlington as a tribute to our service members? The tours are conducted, et cetera. Does the government need to inventory any tribal members buried in Arlington?
No, Your Honor. Carlisle is not like Arlington. Carlisle was established because the government dug up these remains without consent of the families and tribes and moved them to build a parking lot.
What's the statutory difference? Where do I find that difference in the statute?
In the ordinary definition of holding or collection, because based on these specific facts that we have here, that Carlisle is a holding or collection, but these facts do not mirror facts of comparable to Arlington.
So it's a holding or collection, but Arlington isn't, because why?
Because the government treats these remains at Carlisle Cemetery as a holding or collection.
Sorry, help me understand that. How do they treat them at Carlisle that way, but not at Arlington National Cemetery?
because of the lack of consent, there was no expectation that Samuel and Edward would die at Carlisle and remain at Carlisle forever. That they would be moved.
So the definition of holding or collection involves lack of consent to be in said holding or collection.
Well, it's presuming that the government has acquired the remains somehow, or has collected or obtained the remains somehow and is using them in the character that makes them property or makes them something that the government or museum can study or is using as for an exhibition. So it's based on those specific facts of holding and collection. And what's helpful is in Thorpe, the court talks about holding or collection, and it says that holding or collection means something that the government is holding or collecting for a purpose other than serving as an original burial site. And so at Carlisle, we have two different scenarios where Samuel and Edward's remains are not their original burial site and have never been their original burial site because there is no lack of consent. There is the lack of consent from the tribe and the families. I see my time is up. Thank you.
Thank you. We have some time on rebuttal. And Ms. Roundtree, I'll hear from you.